My name is Candace Clark, and I'm the Director of Chicago Normal's Social Equity Applicant Technical Assistance Series, also known as the SEAT Series. Thank you so much for joining us for another edition to our SEAT Series, sponsored by Green Thumb Industries and the Licensed Education Assistance Program. In this first video, you're going to hear from Maurice Rice II, a staff attorney at Cabrini Green Legal Aid. He'll be presenting on the topic, Fair Chance Hiring, what employers in the cannabis industry need to know when hiring employees with criminal records. CGLA has now grown to be a citywide, countywide, and statewide leader in supporting low-income individuals who've been negatively impacted by the criminal justice system. So with that being said, let's start this series off the right way. Here's Maurice Rice with CGLA.
Hello, everyone. My name is Maurice Rice II, and I'm a staff attorney with Cabrini Green Legal Aid. And thank you for attending this presentation on Fair Chance Hiring, what employers in the cannabis industry need to know when hiring people with criminal records. We at CGLA are pleased to partner with Chicago Normal to provide information that will help you assume your new role as an entrepreneur and as an employer within the cannabis industry. Now, we know you have lots of questions, so this presentation is designed to answer some of the most common ones that we believe you will encounter as you set up your business. Questions like, what is a criminal record? How can a criminal record affect employment? How do employers get information on an applicant's criminal record? What laws govern how employers use background information within the criminal history background check? What additional laws govern employers within the cannabis industry? And lastly, at the end of this presentation, we'll summarize everything that has been presented before you today. Most often, a criminal record starts with an arrest. When that happens, a record is created in the police department or arresting agency's database. Illinois law requires that the arresting agency notify the Illinois State Police of every arrest. The ISP, in turn, will then notify the FBI. Even if a person is released without being charged, a criminal record now exists in 3 places. If the state's attorney ultimately files charges against that person, another record will be created within the circuit court's database. Once the case is resolved, the court is required by law to report that disposition of the case to the Illinois State Police. However, a person does not have to be arrested to have a criminal record. If an individual or an entity files a credible criminal complaint against another person, then that person will receive a summons to appear in court to answer the charge. When this happens, for example, if a person alleges that another person committed an assault or battery, but the police were not called to the incident, it can also happen when the state obtains an indictment from a grand jury that charges the individual with a felony offense. If that happens, a court case will be created within the circuit court. The court notifies the Illinois State Police of the case and the disposition, and the ISP will then in turn notify the FBI. Now we'll talk about what happens after an arrest or complaint is filed. There are 2 possible outcomes after an arrest or complaint. The event will end with either a conviction or a non-conviction. Now, obviously, a non-conviction exists when a case that is dismissed or thrown out of court, or where the person is found not guilty, or if the person was arrested but not charged. Now, you might be surprised to know that a case could end up as a non-conviction, even if the person is found guilty of an offense. Oftentimes, this happens in a case where what we call a non-conviction sentence is imposed. Usually these special sentences are given when it's the first time a person has been found guilty of a crime. Some examples include where an individual is given a sentence of supervision or special probations that result in the case being dismissed if that person fulfills some obligation, such as community service or satisfactorily completing a drug treatment program. Now, once you know whether a case is a conviction or a non-conviction, you'll know what type of relief may be available. Generally, a non-conviction might be eligible to be expunged, while a conviction might be eligible to be sealed. We won't go into the details of what type of offenses are eligible and which ones are not in this class. What is important for you to know, however, is the difference between expungement and sealing. If a record is expunged, nobody can see that record, not even law enforcement, except for those special cases where the person received a special probation that did result in a non-conviction. But law enforcement, including the police, the courts, state's attorneys, they can see a record that has been sealed. But you as an employer cannot see any misdemeanor cases that have been sealed. A sealed felony case, however, it can be seen by employers who are allowed to do so based upon a fingerprint-based background check. People who work in the cannabis industry have to be fingerprinted to obtain their agent identification cards. Later in this presentation, we'll discuss how that process works and what your role can be in giving people with a criminal record a fair chance at employment within the cannabis industry. Next, we'll talk about how a record can affect a person's ability to get a job. We're going to talk about background checks a little later on in this presentation. In the United States alone, there are over 40,000 statutes that impose collateral consequences on people that have been convicted of crimes. These collateral consequences then create barriers to individuals obtaining jobs, housing, benefits, and even affects their right to vote. More than 80% of the statutes operate as a denial of employment opportunities. Here in Illinois, you can see some of the statutes on the above presented slide that show you how it affects an individual's obtaining a job, obtaining benefits, housing, or employment. Statutes presented in the above slide show you how they can be a barrier to an individual obtaining employment or volunteering based upon the category of offense which they've been charged and convicted, as well as some of the collateral consequences once they serve that sentence and how it affects that person moving forward. Here are 3 examples of restrictions that have been imposed on people who have criminal records. We'll talk about the impact of a criminal record on a person wanting to work in the cannabis industry later on. Here are more examples of additional barriers to an individual with a criminal record. The strike-through and insertions are changes that have been made to the law as a result of advocacy by Cabrini Green Legal Aid as a member of the Restoring Rights and Opportunities Coalition of Illinois. While we have made significant progress in making the laws more just and fair in considering criminal records, we still have a long way to go. But knowledge is power, and by the end of this presentation, you will begin to feel empowered to know exactly how you can make a difference as an employer within the cannabis industry. Let's talk about the background check. There are 2 viable alternatives to discuss background checks. One method is to use a third-party background check company like HireRight, Good Hire, or IntelliCore. Usually the cost varies based upon the number of jurisdictions you want to search. Then there's a fingerprint-based background check. This is the type of background check that is required for the agent identification card for all your executives and employees. Under Illinois law, a dispensing organization shall ensure that each principal officer and each dispensing organization agent has a current identification card in the agent's immediate possession when the agent is at the dispensary. Additionally, all principal officers, agents in charge, and agents of a dispensing organization are dispensing organization agents and shall hold an identification card. No person shall enter a dispensary to begin work at a dispensary prior to holding an agent identification card. Let's talk about some of the laws that govern how employers are to use the information contained within a background check. In Illinois alone, various laws include Ban the Box, the Illinois Human Rights Act, the Criminal Identification Act, the Uniform Conviction Information Act. Additionally, federally, the Fair Credit Reporting Act governs how an employer may use information contained within a background check. Private background checks are governed by the Fair Credit Reporting Act, which requires the following. Employers must get permission to run a background check. A person must sign off before the background check is run. Employers must also give applicants a copy of the background check report before they deny a job or promotion if the denial is due to a criminal conviction. Oftentimes, this is called a pre-adverse action letter. In Illinois alone, the employer has to wait at least 7 days before taking the adverse action. You can provide mitigation or correct inaccurate records during this 7-day time span. If the employer denies a job because of a person's record, the employer must give the applicant a copy of the background check report in that pre-adverse action notice mentioned earlier. They must also give the applicant a reasonable amount of time to respond. In Illinois, this is often 7 days. That's required for the Illinois State Police report. You must then get ready for this by in writing, which is called a mitigation letter. It's a letter that acknowledges the conviction, and it also talks about a potential applicant's prior accomplishments or prior things that they've done in their life since that conviction. If the applicant has applied online, the employer then has 3 days to give them the name and the contact information for the reporting agency. There are things background check companies must do. They have to use fresh information. They have to correct inaccurate information as well as also inform applicants of the process to dispute and correct inaccurate information based upon that background check due to the Fair Credit Reporting Act. They must also give applicants a free copy of their background check report if they ask for it within 60 days of receiving notice that they were not hired. There are substantial penalties for employers and other agencies for non-compliance. For example, in one case, there was a $3.9 million fine for failure to provide the requisite disclosures before running a background check. And in some cases, failure to follow the two-step adverse action process where the denied employment was based upon information within that criminal background report. Exempted cases, however, the provisions of paragraphs 1 through 5 of subsection A are not applicable in any case of any consumer credit report to be used in connection with a credit transaction involving or which may reasonably be expected to involve a principal amount of $150,000 or more, the underwriting of life insurance involving or may reasonably be expected to involve a face amount of $150,000 or more, or the employment of any individual at an annual salary which is equal to or which is reasonably expected to be equal to $75,000 or more. Under Title VII of the Civil Rights Act of 1964, an employer can ask questions about an applicant or an employee's background or require a background check, but the employer cannot conduct background checks or use information obtained to deny equal employment opportunity to anyone on a protected basis, either by intent or by unlawful desperate impact. Also, in 2012, the EEOC has published guidelines on the use of arrest and conviction record information. Texas, however, challenged these guidelines on the grounds that the EEOC overstepped its regulatory and enforcement power, and eventually Texas won that case. While the ruling only applies to the Fifth Circuit, it is likely only a matter of time before the impact is felt nationwide. The guidance in that case requires employers to use a balancing test to decide if the person is likely to be responsible, reliable, or a safe employee. The test required the employer to ask the following questions. Is the exclusion job-related and consistent with business necessity? What is the nature and gravity of the offense? How much time has passed since the offense was first committed up until the present day? What is the nature of the job sought? Are there relevant individual factors? This falls under the mitigation category. What has an individual done to rehabilitate themselves and their character since incurring that conviction and now applying to this position? Are there less discriminatory alternatives? While these factors are the bare minimum, organizations must still choose to apply these standards to ensure fairness in their employment processes. Now we'll discuss the Illinois Human Rights Act. It is a civil rights violation for any employer to inquire into or use an arrest record as a basis to refuse to hire or to segregate or to act with respect to recruitment, hiring, promotion, renewal of employment, selection for training or apprenticeship, discharge, discipline, tenure terms, privileges, or any conditions of employment. This means that an employer cannot ask an applicant to give that employer a copy of their rap sheet. A rap sheet is a record of arrests or prosecutions, which is obtained by a law enforcement agency. An arrest record means an arrest not leading to a conviction, a juvenile record, or criminal history record information, which has previously been ordered, expunged, sealed, or impounded under the Criminal Identification Act. The exception to this, however, is a provision that allows sealed felony convictions to be reported if allowed by law. For example, individuals seeking employment within school systems or government agencies. For cannabis dispensary agents, the fingerprints are not sent to the employer, but to the Illinois Department of Financial and Professional Regulation. Under this regulation involving the Illinois State Agency, the Department of State Police shall furnish or follow positive identification of all Illinois conviction informations to the Illinois Department of Financial and Professional Regulation. And as you will learn later, the IDFPR cannot consider records that have been previously sealed or expunged. Applicants who feel their rights were violated have almost a year to file a complaint. If that matter goes to a hearing before the Illinois Human Rights Commission and it results in a favorable decision in favor of the applicant may be awarded monetary damages in addition to back pay. Employers cannot ask applicants if they have previously expunged or sealed their criminal records. This even applies to the Illinois Department of Financial and Professional Regulation, as we'll cover on the next two slides. The entry of an order which affects the expungement or sealing of criminal records, except with respect to law enforcement agencies, the Department of Corrections, state's attorneys, and other prosecutors. An expunged or sealed record may not be considered by any private or public entity in employment matters, in certification matters, licensing matters, revocation of a certification or a license, or registration. Applications for employment must contain specific language which states that the applicant is not obligated to disclose sealed or expunged records of conviction or arrest. The entity authorized to grant a license, certification, or registration shall also include in that application for license or certification or registration specific language that the individual is not obligated to disclose this information. However, if the inclusion of that language in the application is not practical, then the entity shall publish it on its website with instructions and specifying that applicants are not obligated to disclose sealed or expunged records. Employers additionally may not ask if an applicant has had their records previously expunged or sealed. Under the Uniform Conviction Information Act, if the dispensing organization wishes to request a background check, independent of the fingerprint-based background check conducted for the agent identification card, the agency must comply with these rules. They must provide the individual named in the request with a copy of the response. Again, that information the person must be given 7 days to go over the receipt of the information contained and determine if it was inaccurate or incomplete. In Illinois, under Ban the Box, employers cannot inquire about or into, nor can they consider or require the disclosure of a criminal record or criminal history of an applicant until the applicant has been determined qualified for the position and notified that the applicant has been selected for an interview by the employer or employment agency. Or if there is not an interview until after a conditional offer of employment is made to the applicant by the employer or employment agency. This does not mean that employers can never ask the question. The law just says that they cannot ask until later in the employment process. Additionally, the Cannabis Act sets forth parameters for the IDFPR to consider the character of an applicant in deciding whether to issue an agent identification card. But it only requires the dispensing agent to hire people who have agent identification cards. More information can be found on Ban the Box from the following website, www.nelp.org. Additional laws that govern employees within the cannabis industry. Here we'll discuss agent identification cards. Who's allowed to get them? The two agencies that issue these cards, the Department of Agriculture and the Illinois Department of Financial and Professional Regulation. We'll talk about rules for issuing these cards, which are governed by fingerprint background checks, as well as hearings for an individual who has been denied an initial card. The following are the types of jobs that are available within the cannabis industry. These jobs include craft grower, which is a facility which is licensed to cultivate, dry, cure, or package cannabis or perform other necessary activities to make cannabis available from the point of sale at a dispensing organization or use at a processing organization. Other positions include work at a cultivation center, an infuser organization, processing organization, transporting organization, as well as a dispensing organization. The dispensing organization is a facility which is licensed to acquire cannabis from a cultivation center or craft grower. And from then, they're allowed to sell the cannabis to purchasers under the Act or individuals who have been deemed qualified, registered medical cannabis patients and caregivers. The following are a list of positions which are also licensed within the cannabis industry under the Department of Agriculture. With regard to an agent identification card, an agent includes all types of jobs within the cannabis industry. It ranges from principal officer to board member to employee, or an agent of the various positions which I listed to you earlier, and anyone who is above the age of 21 years of age. Everyone who works in the cannabis industry will need to have an agent identification card prior to working within this industry. Who can apply? A person must be hired by a dispensing organization before they can apply for a dispensing organization agent identification card. The license application, while not available on the IDFPR website, but the above provided link also contains a frequently asked questions document, as well as additional information to show you how to undergo the application for licensing. Now we'll discuss some of the background checks which take place regarding licensing within the cannabis industry. Under the above provided law, the Department of State Police shall conduct a criminal history record check of the prospective principal officer, board member, or agent, which seeks to obtain an agent identification card. Such fingerprints shall be transmitted through a live scan fingerprint vendor, which is licensed by the Department of Financial and Professional Regulation. The Department of State Police shall charge a fee for conducting the criminal history check, which is deposited into the State Police Services Fund, and it shall not exceed the actual cost of the state or national criminal history record checks. Per the accurate biometrics, which is a live scan vendor's information, the applicant shall be given a computer-generated receipt upon completion of the fingerprint process. The fingerprint-based background check response will automatically be sent to the Illinois State Police to the appropriate state agency. Also, that should be taken of note is that having a criminal conviction does not disqualify an individual from getting an agent identification card. The following are a list of mitigation factors and evidence of rehabilitation that can otherwise assist an individual with a prior criminal conviction in obtaining their agent identification card. Factors that these agencies look at are the lack of direct relation to the offense with regard to the duties of the position that they are applying for within the cannabis industry, the amount of time that has taken place since the person has applied for an agent identification card from the date of the offense. It should be noted that 5 years is required since a felony conviction or 3 years since release from confinement for a conviction, whichever is later, that must be passed without having a subsequent conviction. Additionally, these agencies look at whether an individual has previously held a license or was employed by the state. They also look at lack of prior misconduct arising from or related to the licensed position, the age of the person at the time that they committed the criminal offense. They also consider whether the applicant would be explicitly prohibited by federal rules or regulations from working in the position for which a license is sought, as well as successful completion of that person's sentence. And for applicants serving a term of parole or probation, a progress report that documents the applicant's compliance with the terms of the supervision or probation. Other factors include the present fitness and professional character of an applicant, whether or not the person was issued a certificate of good conduct from a court or the Uniform Code of Corrections Agency, whether a certificate of relief from disabilities was issued, as well as any other mitigating factors that can only contribute to a person's potential and current ability to perform their job duties. Additionally, these agencies, because it's a matter of public interest and concern, they look at whether or not a person is of good moral character. Based upon these varying factors, the agency is authorized to revoke, suspend, refuse to renew, or place a person on probationary status, issue fines, or take any other disciplinary action as they may deem warranted against a licensee or registrant whose conduct violates the continuing requirement of good moral character. No application for licensure or registration shall be denied for a reason by finding that a person lacked good moral character when the finding is based solely upon the fact that an applicant has previously been convicted of one or more criminal offenses. In the reviewing of this process, a prior conviction of an initial applicant for the purposes of determining good moral character, the department shall consider evidence of rehabilitation, as well as other mitigating factors in the applicant's record, including those set forth in the previous subsection A of this act. And as we discussed before, the importance of an individual in getting their records sealed and or expunged is that these agencies shall not require applicants to report information that was otherwise sealed or expunged. This includes juvenile adjudications of minors who were determined delinquent at the time of an offense. It includes records of arrest which were not followed by a charge or conviction, or records of arrest where the charges were ultimately dismissed unless related to the practice of the profession. Convictions that are also overturned by a higher court cannot be considered by these licensing agencies, as well as convictions or arrests for individuals that had previously had those records sealed and or expunged. The Illinois Department of Financial Professional Regulation, frequently they publish the information on their website regarding disciplinary actions that have been taken by their department against a licensee or an applicant pursuant to any licensing act administered by the department. You can visit their website to obtain additional information regarding these disciplinary measures. It should also be noted that no later than May 1st of every year, the department must prepare and publicly announce and publish a report of summary statistical information relating to the new licensing, certification, or registration application process during the preceding calendar year. These are just information tidbits that you as an employer should know, because this information is made public every year. With regard to the Department of Agriculture administrative hearings, any individual which is accused of violating a provision of the act, they must set a hearing date at least 30 days prior to the hearing, where an individual must receive written notice of the charges that were alleged against them, as well as notice and time and place for the hearing of the charges. This written notice may be served by delivery, personally to the accused, or by mailing notice to the registered or certified mail address to the physical address on record. This is additional information regarding the requirements that the licensing agency must follow in setting a hearing. Again, an individual must be afforded notice prior to the hearing taking place to determine if the individual is in violation of a licensing act. So I know we've covered a lot of information here for you to digest today, but to summarize it up, we want to just ensure that you as a potential employer within the cannabis industry, it's important that you do not implement blanket rules to exclude people from employment with your organization. You must provide sufficient time for mitigation or correction of an individual's record if there is anything that is adverse contained within that record that comes to your attention or the applicant's attention. Please explain your process up front to any potential applicant prior to beginning the process and assisting them in obtaining their agent identification card. And as a part of explaining your process, ensure that you explain thoroughly to that potential applicant how the background checks will be conducted. And please decide in advance who will pay the fees for obtaining the agent identification card. Again, we've covered here what is contained within a criminal record, how a criminal record can affect an individual's employment, how employers get information regarding an applicant's criminal record, what laws govern how employers may use information contained within a background check, and the various additional laws that govern employers within the cannabis industry. If you have any questions with regard to the information that has been presented before you today, please do not hesitate to reach out to us at the following email address. That's fairhiring@cgla.net. Once again, we thank you for sitting here and obtaining, this information that has been presented within this this presentation, and we look forward to continuing to partner with NORML as well as yourself as you enter into this cannabis industry. Thank you and have a great day.